Welcome back, everybody. Ros McInnes mentioned the stars aligning in Scotland as a precursor to reform. And the Russian invasion of Ukraine has heightened concerns, particularly at the SRA, so this is regulatory authority, around SLAPPs, especially claims bought by wealthy elites intended to intimidate, to induce fear, to be time-consuming, both financially, commercially, and psychologically. And lawyers are usually held to the highest professional standards, including precluding that dealing with that which is inappropriate or abusive in terms of litigation, especially where the target is an unrepresented individual or there's some kind of economic disparity in financial resources. So we're really lucky today to have a real cornucopia of talent to help us look at not just SLAPPs, lawfare, but also the ethical underpinnings for lawyers. And I'm joined today by investigative journalist Dan Needle, immediately to my left, solicitor Matthew Jury, media counsel Piers Sarma, who many of you will have read her op-ed in the Times on SLAPPs last week, and of course the recently re-anointed King's Counsel Keelan Gallagher. And with the able assistance of that panel, we're going to look at the grey area of where perhaps it's lawful, but it's professionally inappropriate to be a legal enabler. And I think it's that area which perhaps hasn't had the same level of attention to date as we'd perhaps like. Now, Dan, I'd like to start with you and your best friend, Nadim Zahawi. Do you want to just inform the audience about why you're such good pals?
So I should probably start by asking you to retract the libelous accusation I'm a journalist. I'm one of the few professions less popular than a journalist. I'm a tax lawyer. I was head of. You're welcome. I was head of tax for Clifford Chance, large law firm. I retired to set up a small think tank doing nerdy tax policy stuff read by about 200 people, but the right 200 people. So someone, I can't remember who it was, someone pointed me in the direction of a 5-year-old Guardian article about Nadim Zahawi. And without casting aspersions about the Guardian, it was a typical Guardian article in that it saw that he'd done something involving a tax haven, pointed at that as if that was a big scandal, and then stopped. And I could see that actually there was something going on that was very interesting, involving clear tax avoidance that was on the edge of evasion. So I wrote about it. And he gave a defence, which I didn't think was very credible. And I said, well, either I'm misunderstanding or he's lying. Don't know which. He then dropped that defence and came out with a new contradictory defence. And I said, well, so he was lying the first time. Then I was sitting by the side of a lake watching my kids splash in the water, get half drowned. And I suddenly got a Twitter message from a lawyer from Osborne Clarke, who I didn't know. Never really came across Osborne Clarke, but I'd heard they were acting for Zahawi. Someone naively told me they were helping him clear up his tax affairs. Don't think that's what they were doing. And he said, can we please have a talk? I'd never really been involved with libel very much, but like most commercial lawyers, I know how the law of confidentiality works. So I said, please put anything you want to say to me in writing. And by the way, I only accept open correspondence. Silence. Thank you. Then later that day, I received an email which purported to be without prejudice and confidential, asking me to retract by the end of the day, or I would receive open correspondence. Presumably, I read that as a threat to sue me. So I concluded quite quickly from my imperfect knowledge of confidentiality and without prejudice that those claims were false.
And must have been knowingly false to the law firm.
Knowingly false, because they didn't just drop them in passing. They said it would be improper for me to publish. They implied there was a legal prohibition on publishing without prejudice correspondence, which is a lie. But so what I did, I didn't retract. I doubled down and I explained why I'd said what I had. But I didn't mention their letter yet. I wanted to draw them out. That succeeded. I then got an open letter the next day. Clearly, they began to realize what I was doing because the letter said, this is not a libel threat. And you can't say this is a libel threat, but it was a libel threat. It wasn't friendly correspondence giving me more information. And I then published their correspondence that they told me I couldn't publish.
Jolly good.
I then discovered, to my, I don't think I'm a particularly naive person, but I was shocked to discover it is in fact standard practice in the libel solicitor world to send letters which you assert are without prejudice and or confidential and cannot be published. And that many people who then corresponded with me, bloggers, tweeters, normal non-lawyers, normal people, received letters like that, believed them, and shut up. And then I discovered that even in-house lawyers in large media organizations would often assent and not publish these letters. And I thought, that's not right.
Yeah, I think it isn't right. And what's interesting is, Pierre, you had a case for Global Witness where, what did you do when you got their letter before action? It was from Shillings, wasn't it?
It wasn't actually a letter before action on that one, Mark. I worked with Mark many years ago, and so we were representing Global Witness, and they were a long-standing client. We had a call right at the end of the day on a Friday evening from one of their junior associates, who, from memory, had literally been presented with a bunch of documents on their chest as they left the building in Clerkenwell or wherever they were at the time. So they'd open the door to go on a Friday evening, not being a sort of 24/7 kind of publication. And they had put up on their website bank statements relating to purchases by Denis Sassou Nguesso's son. So he was the president of the DRC at the time, and his son had been on a spending spree.
Congo-Brazzaville, yeah.
Sorry, Brazzaville.
Congo B, yeah.
Sorry. Yeah, and we basically looked at the pile of papers, and it was Shillings saying, we're going to apply for an injunction to get the stuff down. And Global Witness quite rightly phoned immediately for legal advice. And we went before the court on an application for an injunction, which was defeated. They'd brought the application on the basis that an injunction had been granted in Hong Kong, as it happened on improper grounds. And I can't remember the judge, but it was an absolutely brilliant judge.
Stanley Burnton,
because he said this is self-evidently in the public interest, because what it showed, the spending spree that he'd gone on, sort of, Louis Vuitton and Gucci bags in Paris and going off to the Bahamas and spending again. And they had traced the money, as Global Witness does, through to state assets. I don't think they actually had, absolutely nailed where the money was coming from. There was a strong inference, a question mark being asked about where the money had come from and was it improper or not. And I think it's fine to say broadly financial material and bank statements are not appropriate for publication, but you can only say that if there's no public interest.
Yeah, I mean, I think that's really interesting because a lot of what we're talking about with SLAPS is about the public interest. But I was going to come back to the labelling point, because as I recall it, Shillings rather pompously labelled their letters not for publication, strictly private and confidential. And I think you put their letter, the article, and your response up on the Global Witness website.
Yeah, that's right.
Yeah, which was sort of a Streisand disincentive.
Yeah, I mean, we do pause on that. And I know when your scandal affair, Fury, clicked through, we had reporters pick up on it and come to us in-house. Some lawyers were very cautious, and they said, we're on notice of the confidentiality because Osborne Clarke have notified Dan that there's confidentiality in this. So if we were to breach it, and there was a lot of caution. So it's very effective. You can see that going into in-house lawyers at the times. But we have an approach on this where we basically say, let's look at the confidentiality. And if it's being used as a veil, we don't care. And that's, I think, this example that you're looking at is where I first started thinking about the public interest in the subject matter. You look at that first, regardless of the label.
And I thought what's interesting is, coming back to you, Dan, is that it's this labelling of correspondence. So today at lunchtime, by lucky coincidence, there's a warning notice gone out from the Solicitors Regulatory Authority, which sort of builds on the guidance that they issued back in February. And there's a whole section on mislabeling of correspondence, particularly to individuals. And I suspect it's a lot out of your case, Dan, because essentially they're saying it's a gross breach of the rules to mislead recipients of your correspondence, and for that read higher duty to litigants in person and journalists who are not lawyers and don't have an in-house legal team. If you mark things not for publication, strictly private and confidential, where you haven't agreed to it, and of course without prejudice. And this, I think, is quite an interesting issue, because I think one of the takeaways here was, going back to the first panel, was around mislabeling of correspondence and how often that happens, and whether or not actually one of the things we should be doing is looking at the sort of full surfeit of people who've had these kind of issues. Are you aware of it being a wide-ranging issue?
I'm aware of it being almost in every case where an unrepresented writer, blogger, tweeter, whatever the noun is, has received a libel threat, it's been stated to be confidential and they've been warned not to publish it. And as far as I can see, in almost every case, that will be a lie. In fact, you need to be quite imaginative to think of a case where a libel threat will be confidential. The example I came up with is the Osborne clerk wrote to me and said, yes, our client did say something that wasn't true, but it was put out by his press officer because his mother had just been run over by a hippopotamus, and that's highly confidential information, and we haven't told him yet, and we're telling you this to give you the full picture. In that circumstance, there would, I think, be confidential information in the letter, and maybe it would be fair to impute a duty of confidence to me. But outside of cases like that, where a genuinely confidential explanation is being given, I can't see it.
Well, and also, I was very pleased to see, albeit reading in a cab on the way here and frantically on my phone just now, not very subtly, the SRA warning notice today, hot off the presses. It's quite robust on this topic. And ultimately, many of these cases where what's happening is a meritless legal claim or threat of a legal claim to try to shut down a matter of public interest, often against a private blogger, someone who's unrepresented, doesn't have deep pockets, and so on. Quite often, the very attempt to shut it down, there'll be a public interest in reporting that too. And it's good to see quite a robust indication of what is unacceptable. Because in essence, when you print a warning which says this is without prejudice, you can't publish this, it's a unilateral attempt to impose a duty of confidentiality on the recipient in circumstances where the attempt to shut down reporting on this very act of sending the correspondence is itself a matter of public interest. And it's quite difficult for people, particularly when they're not represented, when they don't have deep pockets, when they're independent, they're litigants in person, to stand up to that. And I think it's hugely helpful to see that from the SRA. However, as the barrister on the panel, I find it very disappointing that in an England and Wales context, the response from the Bar Council on these issues over the last number of months has essentially been, we'll wait until there's legislation. If Parliament tells us to act, we'll act. See what they said in January in their response to the consultation, or their note from May. And of course, barristers can now conduct litigation, and barristers can accept instructions on a public interest basis. And I hope that with the SRA warning notice today, we see robust action from the Bar Council too.
So where you've got open access, barristers working on that basis, they should really be working on the same principles that the SRA is now suggesting.
It's really interesting, and I think we'll come back to that issue and what the obligations are. But Matthew, I wanted to bring you in to talk about President Putin's chef. Evgeny, I'll let you say his name. There are occasions where it's very difficult to maintain the balance between these competing interests. Do you want us to just tell the audience about that particular case, and then I've got a couple of questions for you after that.
Yeah, no, absolutely, of course. I feel a bit of a fraud up here, by the way, because my normal area of expertise is representing victims and survivors of terrorism in civil claims against state sponsors, financiers, etc., which I suppose is how this case ended up with me. The background to this is that in I guess autumn last year, I'm not going to go for specific dates because I'll forget. Elliot Higgins, the founder of Bellingcat, received a letter before action from Yevgeny Prigozhin, who is otherwise known as Putin's chef, very close to the Russian president, and has since become head of Putin's private army, which is Wagner Group. And Wagner Group are, I would say, they're one of the world's biggest threats today, actually. I mean, they're not only they've been operating in the past in Libya and Syria, and in Ukraine. I mean, they first started operations in Ukraine in 2014. They're now all over Africa, Central African Republic, Mali, etc. And they're a private military company ostensibly, but also they are involved in the, for want of a better word, pillaging of natural resources around the world in order to finance their operations. They are an arm of Russia, or more specifically Putin's foreign policy, and for all intents and purposes, they're a terrorist group. I mean, that's what they are, and they should be designated as such. Indeed, attempts are being made to designate Wagner as a terrorist organization, but it hasn't quite got there yet. Anyway, I'm digressing slightly. So I get a call from Elliot, who I'd had some previous dealings with in around the autumn. I say, look, I've got this letter. And honestly, when I first read it, I felt like, well, I did say, I said, I'm not sure this is actually, he's going to pursue this. I mean, surely not. I mean, this is crazy. But in any event, we took the necessary precautions and steps, and we were ready for him if he were to proceed. He finally did serve proceedings, and going from there, it became immediately apparent as soon as we received the particulars of claim. I mean, we knew this beforehand, that I mean, this was ostensibly an abusive process.
Who was acting for him?
Discreet Law, who you won't have heard of because they are very discreet.
Well, they were till now.
They were until now. Yes, indeed. But they are an offshoot of Roger Gershen's firm, which is called Gershen's. So he also, I believe, is the sole owner of Discreet Law.
And do their letters come labelled helpfully with private and confidential?
No, not at all. And partly because, and I might get to this in a minute, Prigozhin wanted this. He wanted people to know that he was suing Elliot Higgins and going after Elliot, because that's how he operates. I mean, he wants to harass, intimidate, and threaten journalists. And he wants other journalists to know that he's doing that. So actually, in this instance, it was in his interest for it to be open correspondence. So there was that issue didn't arise in this case. But as I said, I mean, we quickly identified that it was an abusive process of some kind. The reason I say I sort of feel a bit of a fraud up here is because I was no expert on slaps before this case. But I'd read a little bit about them. They'd cropped up in the press due to some excellent work by some of the people in this room. I'm looking at Susan over there, partly. But it seemed to me that it had all the hallmarks of a slap, and I didn't quite know how to define a slap. But I think, as the U.S. Supreme Court approached pornography, you know it when you see it, and it was just so obviously an attempt to intimidate and silence Elliot. And also the main other aspect was that all Elliot had done, he had retweeted links to news articles from CNN, Der Spiegel, BBC, etc., which were reporting Prigozhin's association with Putin and the fact that he was head of the Wagner Group, and that, I mean, ironically, that he had been threatening, intimidating, and harassing journalists around the world, including some alleged murders that had taken place in Africa. Sorry, I've lost my thread a moment.
You don't need to say alleged murders. You can say murders.
Murders, yes.
Probably now he's sanctioned. He's not going to sue you. Well, not here. Anyway.
No, I don't think so.
I mean, I think that the interesting thing is that the essence of this claim was to put fear, as you rightly said, to harass, intimidate, and to discourage scrutiny of him. Isn't that right?
Look, absolutely. I mean, they could have gone after CNN, they could have gone after the BBC, but they went after Elliot because he was the threat. Bellingcat, his organisation, was the threat, and he wanted them to scuttle off into the shadows, which of course they weren't intending to do, not at all.
I mean, is there something in defending these claims around the sort of Streisand effect of drawing attention to it?
Yeah. What, bringing the claims or defending the claims?
Defending them. Or are they trying to hurry public?
This case feels maybe different.
Yeah, that's why I was just sort of exploring it. Yeah.
Sorry, so I understand the question properly.
But so,
Shall I explain it by?
Yeah,
I do understand the Streisand effect, but in as much as but
is it would Petrosian be discouraged by greater scrutiny from a variety of other?
Yeah, of course, by bringing the claim.
Yeah,
sorry, yeah. No, I think he relishes in the notoriety. I mean, that's again. He was claiming for the distress of the articles that have been published and Elliot's retweeting of them. I mean, this is a man who just sent a bloody sledgehammer to the European Parliament after they sought to designate Wagner. So, I mean, he's not a particularly sensitive individual. So...
subtle.
Yeah. Or subtle.
So, Pierre, I mean, we're looking at how the bill and everything else is identifying slaps, and we're getting some themes come out of it. One of them is the public interest element. But are there sort of other themes that we should be picking up here that we need to think about?
Well, what's interesting about this conversation about how correspondence is labelled is that it's a feature of pre-action correspondence, which I think is almost the greater evil. So it's not the conduct of litigation we're looking at. We're looking at the deliberate chilling of a story in its very beginning, in its conception, which obviously stifles inquiry. And it's also largely unseen. So when we looked many years ago now at the Defamation Act, we always talk about chilling of free speech. And this is the bit that never surfaces. This correspondence, these threats, what happens before an action is actually launched. So libel proceedings are, something else, because in this country the burden of proof is on a defendant. So as soon as that kicks off, you're kind of on the back foot as a publisher, even if you're publishing public interest material. And also, we have a public interest defence, but it is, I would say, and Keelan can probably opine on this too, is that it's very, very hard to use. And it's a real test for journalism. But actually, this kind of pre-action conduct by claimant lawyers fetters even the use of these defences, because you need to make inquiries as a journalist. You've got to ask questions. If you get pushback and you're told that what the answers can't actually be used, then you can't even balance out your reporting. So what we see is questions going out from a journalist. They will consider them and they will decide what of those responses will be included in their article. Or in fact, if their article is kind of going down the wrong way and it's not the right area that they're looking at, and it helps them narrow their target. But unfortunately, if you try and explain this to claimant lawyers who are protecting their wealthy litigants, etc., they don't get this. They actually say that you are harassing their client, you are digging into areas where you shouldn't be looking, and as you've experienced, that you shouldn't be reporting anything that we're saying. I remember now I was threatened by a set of lawyers, and I was told that I would be referred to the Solicitors Regulatory Authority for allowing correspondence that had come to me to be included in a report that the Times published. Because a letter had come into the legal department, it included information which was a response to inquiries from a journalist. We were trying to stack up a public interest defence under Section 4 of the Defamation Act, which requires your reporting to be balanced. So we put in something which is potentially defamatory. We include their response to balance it out, to make it fair, to show that we've made proper inquiries, and that gives us a defence. But they hated that because they said what we'd told you was confidential. And by the way, you, Pia, are in breach of your solicitors, regulatory requirements by actually allowing the
nonsense.
It's sort of Kafka.
I mean, it's interesting because I know some media organisations have, The Guardian, I think Jill spoke about it earlier, where they get a letter like that, which is a letter to legal in response to a journalist letter. They just do a one-line letter to the respondent, just saying, "We've passed your letter to the journalist." And that way you don't get involved.
Yeah, I mean, we generally would copy in the journalists, and I think increasingly we tend to ignore those labels. But what I like about the bill is that the features of abuse are what defines a slap in the model bill. So everyone's been worried about what is a slap, and everyone's saying, well, it's vexatious, it's oppressive, I can't quite get my head around it. How do you define it? Claimant lawyers are saying, well, it's too broad, we can't do this, don't do it, don't do anything, because it's too difficult to understand.
What a surprise.
Yeah, just trying to stop it any which way. But actually, what they've done is say, well, anything which has features of abuse could be considered as a slap, and that includes pre-action conduct. It includes the type of correspondence. And what then I think is now seems to be mirroring that is the guidance from the SRA today, which says we will look at the number of letters, the nature of letters, whether those letters are intimidatory or not, which it's sort of all begins then to come together, doesn't it?
Yeah, and it's quite interesting because the way they've put the warning is that the Solicitors Regulatory Authority is saying we're going to look at abusive conduct in the context of what is said by lawyers on behalf of their clients before and in the lead up to, as well as during litigation. So that kind of opens it up. And
could I say a quick thing, just arising from what Pia just said about receiving threats herself? So one of the features that you see when you look at slaps, so I hate the phrase, I don't think it works particularly well in this jurisdiction. But anyway, we're at the anti-slap conference. I have to use it. Okay.
You could say lawfare.
Yeah. One of the features that you see in some US jurisdictions is that a different type of abusive lawsuit is now going after the lawyers for environmental activists in particular and trying to tie them up with disciplinary complaints. So there's been some really good work done in San Diego by a number of people reporting on this as a trend. I know it's a trend that's been picked up in Canada as well. So one of the things I always find in this space is we have to be very careful when we're crafting solutions that we don't make a cure that's worse than the disease. See fake news laws designed in part to assist journalists now being weaponized against journalists. See anti-corruption laws, for example, which I see weaponized against my clients all the time worldwide. When in fact you have things like in DC next week, a big anti-corruption conference, which is supposed to be about how anti-corruption laws are helpful for OCCRP investigative journalists who are working on anti-corruption, but it's increasingly being weaponized. So it is worth just flagging as a bit of a sidebar that in other jurisdictions, increasingly what we're seeing is use of disciplinary complaints against lawyers to try to tie up the lawyers who are acting for environmental activists. So I think that's something we need to be aware of, particularly where one of the difficulties here, bottom line is that you have an inequality of bargaining power between an individual, a powerful individual who wants to silence voices speaking truth to power at the earliest stage, stifle journalism at the very earliest stage of the story, in pre-action stage. And on the other hand, you quite often have media organizations, journalists, bloggers, activists who are impecunious. And I've got to say, on my wish list of obvious things, and I'm surprised that we don't see this called for more often, is legal aid for defamation defendants in circumstances where you're facing these kind of cases. It's actually one of the main reasons why so many people cave so early when they receive this kind of abusive, bullying correspondence, is that they don't have deep pockets and cost at a very early stage. So I do think we need to be thinking about defamation having legal aid available. And I did a case a few years ago, which was much more like the panel tomorrow, really, that I think Harriet Johnson is chairing, about silencing women. But this was an abusive series of lawsuits brought against a woman by her ex-partner that went all the way to the Privy Council. And a number of us got brought in directly by the Privy Council to act in the case because this woman simply didn't have any equality of bargaining power in the case. It was a completely abusive series of lawsuits. But she, just after that case, ended up being sued for defamation in the courts in Sark. And myself and my colleague got contacted by the equivalent of the Legal Aid Board in Guernsey to say, we think that this may be a situation where her human rights are being abused by the use of this defamation suit, not only because the Privy Council had said she's had 235 cases brought against her in a range of contexts. So they spotted it, but that's what it took. And then they did, on a one-off basis, give her legal aid to defend the lawsuit.
Well, it's
But that's a
interesting.
real problem.
You've kind of opened a door there, because one of the benefits of the McLibel case, the Steele and Morris case against McDonald's and the UK, was that in the European Court of Human Rights, the government said they would grant legal aid in defamation cases where it was in the public interest. And it seems to me that slap cases are absolutely in the public interest, because it's got to be a public interest journalism or publication before it comes forward. So I think there's a sort of test case there for the more creative lawyers amongst us.
Is there another solution to that, though? And I mean, I just posit this tentatively, in as much as bringing in security for costs at a far earlier stage. So, if there is an indication that this is a slap, there is going to be a hearing on that. There's going to be a decision made on that. There are costs connected to that. But even before that hearing takes place, I think that there should be a requirement for the claimant who is bringing the case, given the disproportionate power imbalance between the claimant and the defendant, which is one of those essential elements of a slap.
I think that's really important, Matthew, and I think we should take that as one of our takeaways from today, in the sense that there's clearly some reform needed in Parliament, but also amongst the rules of the Supreme Court, and also in relation to the ethical behaviours. And I think, if this conference achieves something, that will be one of its aims and objectives. I mean, I think what's really interesting here, though, is that I think there's a difference between the obligations that may be on solicitors and on counsel. And you alluded to this, Keelan, with the opening up of direct access, particularly because at the moment the Bar Council is out of sync with the Solicitors Regulatory Authority. And we're now in a situation where the SRA have now twice put forward very clear guidance and a warning now. So they obviously think that it's getting worse, not better, as to when you can. It may be lawful to bring a claim, but it's unethical to do so. It's unethical to be an enabler, whereas the bar seem to have less problems with that.
Yeah, for people who haven't seen it, it's the 19th of May Bar Standards Board response to the Ministry of Justice call for evidence on slaps that's particularly concerning. There's also the January 2022 European response. But on that, essentially what they say is, we recognise we've a role in enforcement in relation to barristers who abuse the legal process through their involvement in slaps. The vast majority of the letter is about the cab rank rule. And of course, the cab rank rule is about you being obliged to accept instructions. It doesn't say anything about your conduct once you have accepted instructions for a client. So I think that's a bit of a smokescreen, but most of the letter is about that. And then at the end it says, in order to balance protection of the rule of law, giving access to justice to those who believe their rights are infringed, against protection of individuals from vexatious harassment through slaps, we think it would be helpful if Parliament could define in legislation the conduct that should be prohibited. This would be the most effective way of providing clarity and consistency across the sector. Final sentence. If this happens, our rules would require barristers to comply with the law. And it just seems to me that's
beyond feeble.
It's pathetic, really.
Can I go on a slight digression here?
Yeah.
So, I'm used to, in my practice as a commercial lawyer, something which I think lawyers see all the time, but lay people don't see, which is the role lawyers have of policing their clients. The financial regulators, HMRC, can't be everywhere. How is it that most businesses mostly do the right thing? And the answer is their lawyers keep them there. Yeah. And when clients say, we'd like to do that, it's the lawyers who say, oh, no, you can't do that. You can maybe do this. But you can't go further than that. And lawyers have an incredibly important and largely unsung role in being the policemen of many of the laws that bind this society together, except in libel, where it seems the lawyers either don't do that at all, or in fact are worse, and it's the lawyers who are encouraging their clients to be more aggressive and more abusive. And the only solution for this is it's not a hard law that can't possibly define behaviour, utterly unrealistic. The solution is giving the lawyers something to be scared about. And
that's
that
so interesting.
has to be the regulator.
Because hearing that from you from outside the the rarefied world of the libel law and the bubble of the media is just fascinating, because it's fair enough for us to say, oh, they're all in it with them, but a lot of letters that you get before action during the course of inquiry, as I was talking about, they will sometimes just look as though they are swallowing hook, line and sinker what their clients are telling them without any inquiry themselves. So they don't interrogate what their clients are telling them. So they're basically being used in that sense as a conduit for information to thwart publication.
Reputation launderers.
And there doesn't seem to be anything to stop them from doing that.
Repeating factual claims, which a second thought tells you are highly implausible.
And that, of course, is a massive feature because, as I said before, the defendant has the burden of proof. So they know that it's almost like they can say anything. I'm slightly exaggerating.
It's interesting because I think picking up on Dan's point and the point that you're articulating as well is that people, this is sort of coming back to why I think this ethics session is really important, because people tend not to think about their professional obligations. We've become more of a business than a profession these days. And I think what's really interesting is, principle one, your duty is to uphold the rule of law and the administration of justice. So it's a basic fairness obligation that so you can't act oppressively. You've got to uphold public trust and confidence. That whole thing about bringing the profession into disrepute is being repurposed in this slap warning from the Solicitors Regulatory Authority, and I think reminding folk of that. So you've got to act with independence on principle 3, which is what you were talking about. One of the things that I think is really interesting, coming back to your point about lawyers being the tool of their clients, is I was involved in a case for Bill Browder about brought by a cop called called by Karpov, about the killing of Sergei Magnitsky. And interestingly, he was a cop employed on $15,000 a year, Russian equivalent, yet he managed to spend over $250,000 with what was Olswag. And it does seem to me...
Where was their AML on that then?
Well, I mean, this is part of it, you see, because it seems to me that this is also a vulnerable area. So one of the questions is that often they put up these straw man type claimants. And I think the straw man claimants are also a problem for the claimant law firms from a professional perspective, as well as the AML issue. I mean, do you want to just articulate that for some of the lay folk in the audience?
Yes. If a client instructed me when I was a practicing lawyer, instructed me to act for them, I need to know where their money is coming from. And if my client is Citibank, that's not very difficult. If my client is Joe Smith, then I need to check. And if Joe Smith is earning £15,000 a year, but is commencing a libel suit, I should be extremely sceptical where the money is coming from.
Yeah. And you've got to bottom that out. It's part of your duty.
It's not obvious to me how that could ever be resolved.
Well, I agree.
And there's no time limit on SRA complaints, so you might want to think about that one.
I think, I think it's also bound up with principle 5, which is about acting with integrity. Because, there's the old trite question when you become a lawyer, what's the most important quality? We all parrot integrity, but nobody actually gives it body and life, do they?
But, I mean, the people who can be giving it body and life is us. I mean, noting your ruling about it potentially being weaponized and reversed, that's a problem that may need to be solved in the future. But right now, when lawyers put out letters claiming they can't be published when they can, when there are obvious AML breaches, the onus is on us to be taking these lawyers to the SRA and be creating a highly hostile environment for them.
And as well as the SRA, Mark, can I just say, I mean, I'm not sure how many people there are in the room who are barristers, but our core duties overlap very substantially with the principles which are in today's warning letter from the SRA, the warning notice. So core duty 1 is observing your duty to the court and the administration of justice. Core duty 3 is acting with honesty and integrity. Core duty 4, maintaining your independence. And your obligations to the court and the administration of justice override even your obligations to your client. And it does seem to me that there's a lack of creative thinking in that kind of very standard response from May, just saying, unless Parliament says something, we're going to do nothing. So I hope we can use this app. I was just going to mention one other thing. We haven't mentioned judges at all. I'm not sure if you're going to get on to this.
Judges.
Are you? Okay.
Oh, yeah.
They're in my sights as well.
But, I mean, one of the things that I think is interesting between solicitors and barristers in this space is that if conflicts in principles, and often these will be close calls between competing interests, but where there's a conflict in principles, the ones that are raised that protect the process and the procedure and the principles of consumers are far more important than your duties to your client. So what that leads you to is that if you've got a legitimate claim, but actually it's for a collateral purpose or it's an obvious slap, then in those circumstances you've got obligations which are to the wider public, to you.
Yeah, and which override the obligations to the client.
Yes.
And if the client doesn't let you override his wishes, you have to part ways. I said to Osborne Clark, you've said to me something which is false. You need to retract. If your client doesn't let you retract, ethically you are required to stop acting. It now appears Osborne Clark have stopped acting, which I publicised today. So we'll see how they respond to that.
Mark, I think the SRA stuff today is very interesting. I think they've gone further than I thought they would. I mean, if I just look at some of the things where they're trying to show what are the red flags of a slap, so-called slap, they're saying you have to look at whether the target is a proposed publication on a subject of public importance, which I like because they're actually focusing on the subject matter of what's being proposed, which the model bill doesn't look at so closely. And then I love this one. They're saying your instructions are, so red flag, your instructions are to act solely in a public relations capacity. Ring any bells for anyone who's been on the receipt of these pre-action letters.
Does that mean where you don't actually intend to sue, all you're trying to do is send that initial threatening correspondence?
Yes.
Yeah,
they've actually unpacked that so that it's actually, if you make an empty threat, that's an unmerited threat.
They often are empty. A lot of the time, these guys, certainly Zahawi, never wants to be cross-examined.
Reputation management, isn't it? Which is some of these things just, exactly, which is not a legal issue. It's a meritless claim.
Yeah.
But you're sending a letter to supposedly protect the reputation of your client. And they actually say if it's brought about a story which is true and does not relate to private information. Now, to be able to assess whether your client's story is true, you have to have asked some questions. So I think they're possibly putting the onus there on solicitors, which is quite a big step.
Not just to launder whatever feeble facts are given to them by the client.
Yeah, and I think what's also interesting is there's this other sort of catch-all, like bringing the profession into disrepute, which is that you mustn't take unfair advantage of your clients or others. And of course, or others is the opposition, particularly if they're litigants in person and things. So I think there's that sort of feeds into the point that you're making, Pierre, about how you've got to, as a claimant lawyer, interrogate your client's position a little more carefully than perhaps you would have done. And one of the advantages of invoking the SRA is that they can come in and demand to see your file so that they will be able to determine whether there was on the file any relevant suggestion that you were going to bring a claim.
Even before that, it's not sort of coming in to look at your files. It's actually you could become the subject of a report.
Yeah.
So if there are rules which say that you cannot do this, then you are going to be the subject of a report. So as a defendant lawyer, you could report this kind of incoming correspondence. So the flag gets raised much more quickly. Now, that's not going to happen quickly enough to enable a publication to go ahead in the time frame that's proposed for news, but it is a big deterrent, I think.
And the thematic review that the SRA say they're undertaking of claimant law firms. Well, I don't know what it is. In one of their replies to me, the SRA say that they've begun a thematic review of law firms that are active in the claimant libel area.
They've gone into a number of claimant law firms and one defendant law firm and looked at their files to see whether there's slap practice going on. And so that's the thematic review, and I think they'll get quiet warnings to those firms to alter their behaviour. So I think we will see something coming out of that. But
clearing up
someone from the SRA will be here tomorrow, so you can ask that question specifically.
I won't be here, sadly.
No,
great if
they will be.
So what are you doing in the thematic review, and what will we, the public, find out about the outcome? Would be good.
Yeah.
There is work to be done in clearing the back catalogue of bad behaviour, even if claimant law firms clean up their behaviour slightly going forward. The SRA can do some of that, but some of that I think needs to be the people who've received these false claims of confidentiality in the past. They need to be proactively complaining to the SRA, demanding that action is taken.
Do you have a
even if it
complaint
was years
pending
ago.
at the moment?
Sorry,
Do you have a complaint pending with the SRA?
I think I haven't formally made a complaint because I was waiting for this to emerge, but I think the SRA have investigated off their own back, and I'm going to be publishing my 2 complaints later this week.
Later this week?
Yes.
Okay, that'll be interesting. Do we know how many complaints on slaps have been?
No, I don't think we do know until tomorrow, but so I don't want to front run that. But one of the things I think really is important is that what has come out of, one of the themes that I detect out of today is very much that there were lots of silos of almost silence where individuals had capitulated because they felt intimidated to do so, and often they have been misled. So if there's misleading correspondence, it seems that perhaps there ought to be a collation of that evidence, because I think that what we will find is that a number of law firms that have particular themes coming out of them, and there will be many examples. And I think one of the things that Justice for Journalists, Foreign Policy and the HRI can do is to bring them together and collate them as evidence for the SRA.
Well, I know we're giving a lot of credit to the SRA here, but you think about what happened with NDAs and the misuse of NDAs in the context of women primarily who'd been abused in the workplace. And one of the evils of what happened there was not only that the women in question were having a legal gag placed upon them, often meaning that they weren't able to even, for example, seek counselling or speak to people in their ordinary circle and so on. One of the other evils of it was that it prevented others from learning about the perpetrator. And there's some very close analogies here. I mean, with the exception of the saber rattling, which is designed to have a chilling effect where you want your correspondence to be public and to terrify people, in many of these instances, what we see are these letters sent with this language, as Dan has said, which is completely inappropriate without a proper basis, going to multiple people. And like you say, Mark, you have silos of silence where multiple victims of the same perpetrator are experiencing this and not realizing that it's part of a pattern of behavior. I do think following up on the NDA issue to try to ascertain how effective the SRA warning notices were is really important. And I think the same in the context of this, how they're going to actually follow it up and get a database.
Yeah, I mean, I think that's one of the things. So one of the questions for me is, if you are the SRA, how do you objectively identify slaps or lawfare? What is it? And there are some indicia that they're giving us, the economic substantial indifference, a difference rather, and all those other things. Can the client afford it? Is there some kind of collateral purpose? Is it a meritless claim? Those sorts of things seem to be objective indicia, and it may be that there are others that we need to pick up. And I'm sure Tom's going to be all over this in relation to the slap reform.
So we've got a complaint filed with the SRA against Discreet Law, and that's pending. We hope to have a substantive response back in September, but I do wonder whether they were waiting before they publish this guidance. And
I keep finding the name so funny, Discreet Law.
I know, I know.
It's like something
they really ought to be front and centre and helpfully identified.
Yeah, but in respect of in respect to the action involving Prigozhin, all of those factors were met. Disbalance in power, a client without really the economic backing to be able to properly defend the claim. There wasn't a proper interrogation of the facts. I mean, Prigozhin has been sanctioned by both the British and the EU for his involvement with Wagner, and you would have thought that his lawyers would have asked some tough questions surrounding that before.
What about proof of funds? What about AML?
Well, that's really interesting. So there have been some emails leaked between Prigozhin's Russian law firm and Discreet Law, and I've seen those emails. They're now in the public domain. You can download them, although I wouldn't recommend doing it without giving them a proper scrubbing, because I'm sure they're full of viruses. But it seems to me, just from the emails, from what I can tell, that there was a very light touch AML and KYC done. And quite interestingly, just a bit of trivia, Prigozhin's mum pays his utility bills. So
does your complaint to the SRA include AML failures?
it does not, actually, and that's a good idea.
Can I ask you to follow up on that?
I will follow up on that, yes, absolutely.
Gosh,
That is something we haven't done.
I really feel that a high-profile SRA action against a few well-known individuals will change the landscape.
Yeah, it will. I think that's absolutely right. I wanted to come back to the point that you raised, Keelan, about education of judges.
Yeah.
I mean, there's a real problem with judges and barristers that they kind of don't get this because they don't have to tangle with these professional obligations. And I'm thinking particularly of Karen Stain, who in every other respect is a really good judge, but saying in the Carol Cadwallader case that it wasn't a slap. I mean, anybody in this room think it wasn't a slap?
So this,
No.
Yeah, I wanted to bring up exactly this. So, you have a situation where that's a case where the ruling is obviously very good in many ways, but ultimately you have a claim which is brought by Aaron Banks of a vexatious nature, intended to silence her journalism, deliberately going after her as an individual on the basis of comments she made orally in a single sentence in a TED talk and what she said on Twitter, rather than going after The Guardian. It had all these hallmarks, which rightly were called out by many in this room right from the outset as being the most vexatious form of slap. And in an otherwise, excellent judgment, you have this comment that this was not a slap. And I do think there's a fundamental problem there. And on my wish list of things, along with barristers getting their act together, and rather than the SRA having to take the lead on this range of topics, legal aid for defamation is training for judges in this space, for judges to recognise the key features of a slap. And I find, I know Jill Phillips is in the room, say on open justice issues, there's been very good training done in the last decade on open justice issues, and you now have much better awareness amongst the judiciary in England and Wales on open justice issues than you did a decade ago. But this is an area where there's a real gap, I think, in knowledge. And it's an obvious area where there's got to be training. But that, of course, only deals with lawsuits when they've reached court.
Yeah.
And much of what we're talking about is earlier. I have one other thing I think
that one of the takeaways there may be to talk to judges about the incidence of slap behaviour in pre-action correspondence and things. I think they're unsighted on that, and I think a lot of barristers are unsighted on it as well. So I think that might be an interesting area to look at. I'm just going to let you come back quickly, Keelan, but I wanted to just say to the audience, if you have a question or a contribution that you want to make, can you put your hand up and we'll get a mic to you? We've got a couple in the back there, so we'll go there, but just quickly.
I'm just conscious here, we focused in particular when talking about professional standards on the SRA and the Bar Council here in relation to England and Wales. One of the issues which we haven't even managed to touch on in this discussion as yet is when you're faced with lawsuits in jurisdictions which are not necessarily rule of law compliant, where the lawyers may not necessarily have the same standards. And I do think on the wish list of actions, we should give some thought to the IBA HRI producing core ethical standards in relation to these types of cases which apply internationally. I'm thinking in particular of a number of my clients who end up being sued by individuals from European jurisdictions like Malta, for example, where the standards are different to here, or individuals who are being sued in other countries who don't necessarily have robust disciplinary processes. And I think we should give some thought to that.
I think that's really important, and as a takeaway, particularly if we fix the problem here or create sufficient professional disincentives, are we going to get into a position where essentially the claims and the threats start coming from abroad?
Well, a displacement rather than a solution.
Do we create rights of countersuing in some US states?
Yeah, I think that would be interesting. Sorry.
Thank you very much, James Nixie, Chatham House. I think Matthew said something about. Sorry, is it Matthew?
Yes.
No, sorry, to your left. To your right, rather.
I'm Dan.
You're Dan, I'm so sorry. I think Dan said something about you've seen evidence of even in-house lawyers being intimidated by letters before action, which say, do not publish, etc., etc. I guess my question is what happened? Have you seen examples of contradictory legal advice or advice where one one lawyer has said it's not a slap, another has said it is a slap. Do you have any advice if you receive two different sets of legal advice?
So I know a reasonable amount about confidentiality law. I'm not an expert. I spoke to numerous people who are. It's pretty rare among lawyers to get completely unanimous, clear advice from a bunch of unrelated people, but that's what I got. It's very clear that a letter which says retract by the end of today or we're going to sue you is not and is not going to import a duty of confidence. It's almost certainly not going to contain confidential information, save in the rare hippopotamus type case. And even if it did have confidential information, even if it did import a duty of confidence, which it won't, there is probably a public interest which overrides that. So it is about as clear as a legal point can be.
It's like a unilateral declaration. I think this is confidential. And of course, if you're getting expert advice, they'll go, don't be silly. But if you're, and this is the importance of the mislabeling, I think, if you're an individual, then you may well believe that it's an unqualified individual may well believe that it's confidential and you mustn't share it. Sorry,
I mean, it's like if I said now to all of you, I'm going to sue any of you who says out of here that I've historically been involved in tax avoidance. How does that create a duty of confidentiality?
Yeah.
And yet there is no more confidential content in these letters than in that statement.
Yeah, sorry.
Yes, Tom Main, University of Oxford. Yeah, fantastic panel. Just want to agree with Pierre on the importance of the pre-publication process. If your organization, be it an NGO or media organization, has a low tolerance for libel risk, they basically say you have to write to anybody you mention. A lot of the people we write about aren't easily found. So that means you have to spend literally hundreds of pounds in registered letters to Russia, to the British Virgin Islands, trying to get a comment, which usually ends up in a libel threat anyway. So there's one solution to that, and that's basically to cut them from the report. And this has a very chilling effect on freedom of speech and researchers as well, because it's often these figures who are supposedly on the periphery of corruption that their names don't get put out there, and they actually turn up in many cases, but without their names being out there, no one can join the dots to show how instrumental a lot of these enablers are to a lot of these deals. So it's not really a question, it's just no,
I think it's a really important point. And of course, the other thing around that is that, that's the blessing of the Paradise Papers and the Panama Papers and such like, because you did actually get to see what some of these firms were up to, and some of it wasn't entirely wholesome. Any other questions?
But getting the names out is so important. This is what these threats stop. You actually can just expunge somebody from that narrative, and it's not just one piece in a course of an investigation that makes it. It's joining the dots. It's putting the jigsaw pieces together over sometimes years, which slowly just tells a story.
Yeah. Could I just say as well? I know many of you in the room have been involved in working with the family of Daphne Caruana Galizia, who I represent, who died in October 2017, so 5 years ago. And before her death, the many letters which she was receiving, you look at that warning notice today, and you look at the correspondence she was receiving. These were threats which were entirely meritless, designed to silence public interest journalism, and she was receiving them by and large from London law firms. So thousands of miles away in Malta, she was receiving. Well, there's a number of them. I can give you the full list. But the family has named them. The family has named and shamed them.
But I think it's quite interesting because, of course, there's no time limit on these SRA rules, and actually they are good evidence of the sort of problems.
And this warning is not changing SRA practice from today. It's saying what the rules have always meant.
Yeah, that's exactly right. Yeah, and it's talking about what the principles are and how they should be interpreted.
And so Richard Moorhead's asked a really interesting question online. What kind of behaviours, other than sending confidential letters, which aren't really confidential, and sending slap claims without care, what is it that libel lawyers need picking up on in relation to that? What other kinds of due diligence would be reasonable to expect from claimant lawyers in the sort of cases? So we've, I think, picked up money laundering AML checks.
Fact laundering. So
Fact
again,
laundering.
the Osborne-Clarke letter to me, it was all about why a bizarre Gibraltar company had received shares in Zahawi's company instead of him. He had none. And the explanation given by Osborne-Clarke was that the company had put in £7,000 of capital. Now that wasn't true. And if they'd asked to see any documentation, they would have discovered it wasn't true. But they didn't. The owners should be on a lawyer making a statement of fact. I mean, looking out for their own clients' interests, never mind anything else.
Yeah, I mean, just coming back to this point, I mean, do you think there's an over-reliance, Pierre, on the burden of proof in the sense that, you know, because it's up to the publisher to prove the truth of the article and to have the evidence of the defamatory allegation, is that made libel lawyers, claimant libel lawyers, lazy?
I think it has, because it takes very little to press the button to try and stop a publication, because you don't have to do any of the work. I mean, post-publication, all you have to say is something's defamatory. Pre-publication, all you have to do is, I think what you're going to publish is going to be defamatory, and you leave everyone to do the running. So you don't have to say much, and what they've done is basically to pile on top of that. To prevent you from publishing. So they will take everything on instructions from their client. And I think they are being lazy, and I see it quite a lot.
But no normal lawyer does that. Normally in your own client's interest, before making an argument, you make sure it can stand up. But here,
that doesn't seem to be a hallmark of the libel bar.
But there's no reason for them to do that. No. If it doesn't stand up, why do they care? Best case for them is Pia's going to spend years running around with journalists trying to.
Well, we've just got an incentive for them, the SRA.
Yes,
but it does rely on them being robust and all the rest of it.
But there's no incentive, or at least up until recently, there has been no incentive for them to carry out those sort of inquiries. No. I mean, in the case in which we were involved, it was absolutely patently obvious that Prigozhin was the head of the Wagner Group, and indeed since then he's come out and admitted it himself publicly. Any amount of even the most superficial inquiries.
But they denied that, did they?
Yes, they denied it. So even the most superficial inquiry, they should have at least have had a second thought.
It's really interesting.
The lawyers asked them to retract in light of what's happened subsequently.
To retract
their letter.
No. I mean, what we've done is we've issued a complaint with the SRA and we're seeking sanctions that way. But you know, I don't think. I mean, I think the point has been sort of been proven at this stage.
Yeah.
Just one very small point. I'm conscious that entirely understandably we've referred to libel and defamation quite a lot. Slaps can, of course, occur and do occur in other areas of law. You know, we obviously see them in intellectual property quite a lot, so misuse of copyright laws and so on, and in relation to privacy, data protection. And unfortunately, in my practice, I now see a whole wide range of laws being weaponized against journalists in attempts to silence them, including anti-corruption laws, anti-terrorism laws, and so on. But it does seem to me one of the other silos that we need to guard against is, I think there's increasing awareness in relation to this in the defamation space. But I'm not sure there's quite the same awareness in the intellectual property space, for example. So one of the very important things from the SRA warning notice today will be to make sure that it doesn't get siloed and seen as being for claimant libel lawyers only, because it simply isn't. And we've got to make sure that the standards that are set in, you know, requiring that claimant lawyers prevent their clients from seeking to threaten or advance entirely meritless, groundless claims, including in pre-action correspondence. We've got to make sure that that's a standard that's upheld wherever the law is being weaponized against public interest journalism, not just in defamation.
And it's really interesting you raise this, Keelan, because I think there's also something that IP lawyers have had to grapple with, this unwarranted threats legislation in relation to unwarranted IP claims, and at least one London law firm came very nastily unstuck with which. But I think what's really interesting about that is that that might be a useful addition to the bill, in the sense that, you know, if you were going to add something to it, an unwarranted claim might also add to the armory of the professionals, because once you make a complaint to the SRA, it's basically out of your hands. It relies on them not to be seduced by the mellifluous words of the claimant libel lawyers. And I think that's part of an issue which perhaps, you know, maintaining some cognizance and power over that. Sorry, there was a contribution question over here.
I just wondered whether, given the SRA warning letter today, whether that might act as a disincentive to the government to actually enact legislation, whether they may take the view that we should see how the SRA warning letter works through, particularly if the Bar Council then do follow suit, and whether the government, it might act as a preventative rather than as an incentive to legislation.
I think that's a really powerful point, well made. And I wonder whether, the organisations which are sponsoring today shouldn't get back in touch with David Davis from this morning and say, actually, this warning should act as a spur to legislation because it's about protecting the consumer rather than vice versa. So sort of get in first. There was some
You need both things.
But it's exactly. Yeah. And actually, I think it fills in a very good gap there because the two do dovetail together.
Yeah.
You need both.
Yeah, no, I think that's absolutely right. Yeah. Do you want to just go to whoever's nearest you?
He's so polite.
Thank you. My name is Mateo Scamo, a journalist, and I would like to ask, just for clarification, is a lawyer obligated by the professional standards to verify the claims made by his client or her client, or are they allowed to just assume anything that the client says must be true?
I think probably neither of those extremes. You're certainly not required to verify. However, you shouldn't be making claims without at least asking on what.
Well, I think that's right. And I wonder, Matthew, how your practice works in this, because if you were going to sign a statement of truth on a claim form, you have a perhaps concomitantly higher duty.
Yes, absolutely. I mean, I would think very carefully before signing a statement of truth, even if it's on behalf of my client. And I mean, indeed, in Prigozhin's case, Discreet Law signed statements of truth on his behalf on all the documentation. I know. So, which is quite staggering, in fact.
Yeah.
That they would even do that.
That seems stupid.
Yes, it does.
Well, I mean, it does mean that they're on the hook for vouching for it on oath.
Yes.
Yeah, that's bad. Very unfortunate.
Yeah. Sorry, there was another question here in the middle and then another one back there.
Thank you. Helen Taylor from Spotlight on Corruption. Just to return to the discrete question of Prigozhin and discrete law, I was really struck by the fact that the solicitor involved, Edward Miller, who, as you say, is at Goshen, but also working for discrete law, asked to come off the record in that case in a closed hearing at the end of March. And I was really struck by, the fact that it was a closed hearing, which the court granted, linking to Catherine's point about open justice, and I think the transparency issue here, but also that was at the end of March, and so it was really triggered by a sort of backlash against, in the context of sanctions and Russia's renewed invasion of Ukraine, and sort of the spotlight turning on to lawyers and their role as enablers, rather than the libel issue, the slap issue being the sort of underpinning issue, as well as the AML issues that Dan's highlighted. And I just, the question is, what would robust and transparent enforcement action from the SIA look like? In this thematic review, I think it's very important that the results of that come out, and what sort of sanctions should we be looking to the SIA to do? What sort of naming and shaming? I don't think a gentle word to the firms is good enough in this context. And the question would be sort of, what is that kind of sharp-edged enforcement action going to look like?
Well, I mean, I wonder whether I'm a bit conflicted in answering this because, quite frankly...
We'd love to know what you think, though.
A statement of truth. He signed a statement of truth which was false, and which he should have known was false.
Well, the language, of course, was, typically lawyerly, in as much as I'm signing this on behalf of my client who believes the statement, et cetera, et cetera. But, you can't do that. No, I mean, I completely agree with you. But I mean, in terms of the sanctions, I honestly think that in this instance, the bringing of the claim, the representation of Prigozhin in this instance was so egregious. I mean, they must have been aware that it was potentially an abusive process, and certainly aware that what it was a slap. It ticks all of the boxes.
But by a group that's been filmed murdering people.
Exactly. Yes.
If that doesn't warrant a striking off, what does?
Well, that's what I'm going to get to. I mean, I don't think anything less than a striking off would be appropriate in this instance, quite frankly.
Well, it's quite interesting. The Solicitors Regulatory Authority point out that there is an obligation on solicitors to report breaches of the rules where they see them. So, Matthew, you had an obligation, didn't you, to report this as as well as because it's serious misconduct.
I did. I mean, I was hesitant to do so. I mean, as much as there's honour amongst thieves, there's honour amongst lawyers, I guess, I suppose. But I wasn't happy about reporting them. I didn't feel good about it, but I felt an obligation to do so. And I felt that Elliot also deserved that vindication too. So, I mean, it was a no-brainer actually in the circumstances.
Yeah, and I think it's quite an important takeaway that, if as a result of this conference over the next 2 days or these 2 days, you think that you've been involved in a case and your solicitor should have reported it to the SRA, now is the time perhaps to raise that and to align that. Sorry, we had another question here.
Sorry, also from the Spotlight on Corruption, Sue Hawley. I had a question actually. Something you said, Dan, about the AML thing. I mean, our understanding is, sorry, just to flag, we did a big report on how the legal sector escapes effective supervision for money laundering. But the adequate consideration defence in poker, every kind of city law firm I've ever spoken to said, oh no, we're completely covered, that we don't need to worry about where we get the money from. And so I just wanted to ask the panel about, what's going on there? Are they wrong? Is it because the regulator's not doing anything about it to police those boundaries of what they can take and what they can't?
I think unless anyone else wants to.
That's okay.
I think one of the issues is that lawyers think they're protected because they have a duty to report money laundering that they suspect. But when you report it, nothing ever happens. So they never say you can't act. And once you've effectively got that imprimatur and blessing, off you go. And up until now, law enforcement has always hoovered up that information and treated it as intelligence rather than acted upon it in relation to wrongdoing. And so as a consequence, I think the lawyers think that they have a get out of jail free card. There is also an exemption for litigation, but it does allow you, if it's the proceeds of crime, there is the possibility that the money can be traced back to the lawyers and they may have to disgorge it. And again, that's a vulnerability amongst claimant lawyers which has never been properly exploited in my judgment. So I think there's some interesting things there. I mean, any other questions out here at the moment?
Mark, I had a quick thing to say,
Yeah,
arising from some of the comments. So I thought to the point about the sanctions, this is going to be really interesting to watch because one of the areas in which there's been a serious concern in the last number of years in relation to barristers' regulation is that there are some pieces of conduct which are now recognised as being serious misconduct, but the sanctions are very light. So with a whole series of types of sexual harassment, sexist comments and so on, you get very, very light slaps on the wrist compared to, for example, things which are perceived as being offences of dishonesty, even if it's, a paralegal under tremendous pressure saying I sent an email when I didn't, that kind of thing is treated as exceptionally serious. Whereas you can be, a male barrister, this is a genuine example, a male barrister called in 1977 who is opposing a woman, calls the woman barrister hysterical and intemperate when told that it's sexist, and the woman calls him up afterwards. He gives a whole series of examples of why it's a biological fact that women are hysterical and intemperate. And he got a £500 fine. That's what he got. Just astonishing.
£500.
£500 fine. So I think one of the really interesting things is going to be, it's not only making sure that this is recognised as conduct which should sound in disciplinary sanctions by our professional bodies, our regulatory bodies, it's also how seriously it's taken, because this is extremely egregious conduct. There's obviously a sliding scale. The example you've got is particularly egregious. Some of it is thoughtless, not interrogating something and sending correspondence without actually giving thought to whether it's meritless. Some of it is, one of the examples today is not just putting private and confidential, but writing without prejudice on correspondence in circumstances where the correspondence blatantly is not a genuine attempt to compromise an existing dispute. It's, a threat, starting a new dispute. But there's a range of conduct. But I think what the sanctions are is going to be so important. So watch this space.
Yeah.
And I think with that, it's the thing we mentioned very briefly was that how these two aspects dovetail together. So the SRA putting an online reporting form up for people to actively use, and how that then feeds in to the model bill, because a lot of this stuff is not going to reach the courts.
Yeah.
So how do you stem that abuse that happens pre-action, that only surfaces through media or through people being very vocal about it? And when you get to the courts, the judges aren't aware of how this stuff plays out. So you need awareness about the whole remit before anyone's going to listen.
I mean, I think one of the things that's really interesting, because we're at time now, is I think collating complaints is absolutely critical, and also facilitating and assisting people to make complaints to the SRA. And I think your idea about a form was also really good, but that might also serve to educate lawyers and judges in the wider obligations they have, because I think these SRA obligations, people aren't really taught about that or think about them in terms of when they're being trained. I mean, I don't think we ever thought about this when we were being trained. And I wonder whether, we should be looking at putting pressure on barristers to have replicate of the obverse of the solicitors' regulatory authorities about their core ethical standards and how they're going to be interpreted. We've talked a bit about legal aid, where there's a slap being used, and obviously that's an area which is ripe for it. And I think, looking at fact laundering and unwarranted threats, I think, is another area. And I think there's a whole piece here about education. And I wondered also whether we should be thinking about unwarranted threats in the IP context and taking those against where there's an unwarranted slap being made. I sort of raise those as questions for you, because I know we're now going to adjourn over a glass of wine, and hopefully that will spark some lively debate and discussion. Go on.
Can I just bring up one more thing? Which
go ahead.
I feel that the most powerful solution to intimidation pre-action is publication and wide dissemination. The whole logic of slaps, maybe not in your case, but in most cases, breaks down if the accusation gets more coverage. There is one thing that people like more than anything else in the world: it's gossip and finding out about secrets. One thing that the internet hates more than anything else is censorship. My original blog about Zahawi had made maybe 2,000-3,000 readers. My blog about the confidential letter I wasn't supposed to publish, and I did publish, 4 million views. And if we can scale that, if the SRA can stop lawyers claiming their letters can't be published, and if we can empower people to feel that they can publish, that could change the whole dynamic.
Well, I think this is absolutely wonderful, and I hope great food for thought for tomorrow and later. And I understand from Pier that the Times is writing a leader on this tomorrow. Awesome. So make sure you all buy the Times on your way in tomorrow. With that, I'd like you to thank Keelan, Pier, Matthew, and Dan.
Thank you, Mark.